Hello and welcome to You Talking to Me. The European Court of Justice has ruled that Safe Harbor, the agreement on data exchange between the EU and the US, is legally invalid. This agreement is 15 years old. It has been used by more than 4,000 companies. So is this good news for European citizens' data protection and bad news for those companies? That's our topic today, and we are going to discuss it with the following guests. Mrs. Birgit Sippel.
Hello.
She's a member of the European Parliament for the Social Democrats from Germany.
Hi.
And Mr. Peter Chase, Vice President Europe of the US Chamber of Commerce.
Delighted to be here.
And we're also joined by Olivier Henrion from our Belgian member RTBF. Bonjour, Olivier.
Bonjour.
Mrs. Sippel, you welcomed the ruling saying that, of course, you were criticizing the Safe Harbor Agreement since a long time, saying that it doesn't protect European citizens' data enough. So what will be the concrete consequence now? Will those consumers be able to tell Facebook, Google, not to send data to the US anymore?
Now, the safe harbor judgment is essential, but of course it's not the solution for all the problems we have with data protection and privacy. But it's a judgment that goes much beyond a single issue like safe harbor, because the court clearly states that whatever we do, if we create laws or have agreements or whatever we are doing, fundamental rights are essential. And the Charter of Fundamental Rights has to be taken into account on all issues. So beyond the question what is now happening with the business area, with the consumers, this will have a follow-up on all the work we are doing on European level.
Mr. Chase, Washington Post was writing that the Safe Harbor Agreement is the cornerstone of transatlantic e-commerce. What do you expect companies to do? Will they leave Europe after that, or will European companies be harmed?
Well, no. I mean, the decision, certainly they won't leave Europe. I think the more important thing for European consumers to bear in mind is that when these companies have entered into Safe Harbor, they've made promises about how they will treat the personal data they receive. The judge's ruling will not change that. Those companies, the 4,400 companies that are members of Safe Harbor, will continue to adhere to their obligations. Their adherence to those promises will continue to be enforced by the Federal Trade Commission. I think that's a very important point. A more interesting point, though, I think goes to what Ms. Sippel was saying. What are the consequences of this decision? How far do they extend? And they could be very far-reaching in a way that I think will affect European businesses and European consumers potentially pretty fundamentally, not just in terms of their fundamental rights.
Can you make an example? If you say fundamentally, it's serious.
It says, because I think what the court ruling has done is it has underscored what the directive from 1995 says, and what they reiterated a number of times in their ruling, that the transfer of personal data to third countries that do not have adequate protections must be prohibited. So now it's not an issue just of the United States and Safe Harbor, but rather it's a question of all countries.
Mm-hmm. This agreement was 15 years old, and it's kind of astonishing that now the European Court was taking this decision. Jan-Anthony Nogues from BFM Business has a question on that.
Hello, thank you for having me. Indeed, there's a point that surprises me a little. Could you please explain how an Austrian law student, Max Schrems, managed all by himself to do something about the Safe Harbor Agreement that was being used by Facebook as its sort of immunity weapon, while it should be the European Parliament's job? Have single European citizens become, in some sort, more decisive, more powerful than the Parliament?
Sippel.
That's a good question, and the answers can be very different. I have a colleague who said it's very well done because this shows that citizens can have a say in political areas. But for me as a parliamentarian, it's a sad story that for at least 10 years, we again and again told that Safe Harbor is not a safe harbor for privacy. but now only to go to court made a change. And of course, it's not the task of parliamentarians every time to run to the court if we want to have a change. So it's to some extent a sad story for Parliament that our remarks on safe harbor never have been heard, and that now a student takes the control. And by the way, Mr. Chase talked about those enterprises who promise to follow some rules. That's one of the problems of safe harbor, because we as Europeans do not have a control if they really follow the rules. And the second point that is coming from the judgment now is that the question of adequacy always has to mean that there is the need of a high level of data protection. So a lot of things are in front of us with follow-up of the safe harbor and other issues.
Is the Commission to be blamed not to have acted earlier?
For me, clearly, yes. Already the former Commission should have taken our demands more seriously instead of saying we can change safe harbor, because now it's clear that you can't change only safe harbor, but you have to work together with the United States to talk about either changing the rules, giving more control, and as a first step, to check really if adequacy is there and not only make a political statement about that.
Mr. Chase, 28 national agencies met and now gave the European institutions 3 months' time to come up with a solution. Can this safe harbor agreement, after this ruling, be reformed, or do we have to set up a completely new agreement?
Well, with respect to the United States, yes, it can be reformed. And in fact, there have been ongoing negotiations between the European Commission and the U.S. government about that. I think it's interesting to point out that the European Court of Justice, in ruling about the United States, cited 2 reports that had been provided by the European Commission in 2013, where they raised what they thought were concerns about the adequacy of data protection in the United States. Since that time, of course, a number of things have happened. In fact, even in January of 2014, President Obama issued a presidential directive with respect to many things governing the collection and use of data. The U.S. Congress, earlier this year, passed something called the Freedom Act, changing a number of programs in the United States and strengthening the controls of personal data. And they did so also pursuant to court judgments in the United States that outlawed certain programs that had been used by the National Security Agency. In addition, since then, the U.S. and the European Union have been negotiating something called an umbrella agreement, which goes to the issue of exchange of data for law enforcement and other purposes.
But this still doesn't seem to satisfy European level, Mrs. Sippel.
Not totally. Also on the umbrella agreement, we have some doubts. Some progress has been made, but it's not yet finalized. And the umbrella agreement is, like the word says, only the umbrella. So it has some influence on the agreements we will have in future times, but it's only an umbrella, and we are still in negotiations, and we will have to wait what the outcome will be.
Mm-hmm.
I think in this connection, it's important to bear in mind that the underlying directive about which we're talking is specifically it's primarily about the way in which personal data is used by businesses. There is actually, the scope of it is limited in the Article 2 so that it does not apply to things concerning public order, public security, national security, law enforcement. And it's interesting to me that actually this debate has gone well beyond the scope of the underlying piece of legislation, which was, of course, adopted by the Parliament and the institutions, and pursuant to which the Commission concluded the Safe Harbor Agreement. I think that in negotiating the Safe Harbor Agreement, the Commission did its job. It created a program that gives some certainty in a third country that the data of European citizens will be protected. I think, in fact, they did a very good job.
Olivier, you made an interview with the president of the court, and he also mentioned that this ruling, like Mr. Chase mentioned before, might not only affect American companies.
Indeed, basically, as you stated earlier, it said that you cannot transfer personal data to a third country that could not guarantee the same level of protection. Therefore, my question is very simple to our guest. Does that mean that the European Union economy might be disconnected from the rest of the world? Because, as you said, there are only three or four countries.
That is an extremely good question that people need to think about.
And what's your prediction, your answer?
That's two different things. The European Court of Justice ruling is very clear. And you mentioned the meeting of the data protection authorities last week. They actually said again that it should not be permissible to transfer any personal data to any country that doesn't have sufficient, I think it was the reference was to sufficient democratic accountability or something of that nature. And I begin to wonder, so what countries can Europeans engage with on the internet? Is Europe thinking about creating, and I have to use this here, a Euranet rather than an internet? And what is the impact of that on the citizens of Europe? It's going to be an interesting thing because I think that there are many, I believe very strongly, that there are many, many countries that assure nowhere near the protection of civil liberties that the United States government provides.
Mrs. Sippel.
For the time being, I do not believe that there are clear plans to create a Euranet. But of course, we have to have an eye on further developments. And we have to make a difference between the exchange of, let's say, more technical data.
We are almost at the end, but we got a question from Pia Oppel from Luxembourgish Public Radio 100.7. Hello, Pia.
Hello. So my question is referring to the efforts made by companies like Google, Facebook, Apple and Microsoft to actually convince the US government that it has to limit its data collection programs and to make them more transparent. These companies fear about their reputation when they can't guarantee to all their customers that a high level of data protection is guaranteed. So my question for Peter Chase is, do you think that the safe harbor ruling could actually strengthen US companies with regard to their request that internet surveillance is even further restricted in the US?
Well, actually, that gets to the comments that I made earlier, my opening remarks. First, these companies take great pride in the way in which they work with their clients and their customers on their personal data. And they've made tremendous strides over years in terms of trying to make these rules clear and easily accessible by customers. And I think that there's been a tremendous improvement there. They have been concerned that there is the perceptions about the United States and the United States government have an impact on them and on people's trust in them. And what's interesting is that, as I said, even in January 2014, the president was already making changes and significant changes to what NSA could do. The two primary authors of the Patriot Act, Senator Leahy and Congressman Sensenbrenner, have gone out of their way to say that what that act did not allow the National Security Agency to do what it has done. And they have indeed, as I mentioned, President Obama signed into law in June of this year something called the Freedom Act, which indeed does restrict what the NSA can do. So I think that all of this helps address these perception problems.
Mm-hmm. And Safe Harbor will improve or will, change the situation, you think, this ruling? Because the things you mentioned were even before the ruling. So what will be the consequence of the ruling?
Well, this is actually, to me, a question. The U.S. government was not asked to make any representation to the European Court of Justice. The European Court of Justice based its ruling on two commission reports from 2013. The Advocate General based his own opinion on the reports about the PRISM program in the newspaper. And I'm actually quite surprised, in fact, that there was no reference to any of these things that had been happening in the year and a half since that are all material to the question of whether or not the U.S. government provides adequate protections or is under adequate democratic control, which I believe as a U.S. citizen that it very much is.
Okay, at the very end, maybe a question we got on Facebook from the organization La Quadrature du Net. They want to know if the ruling will be taken into account in negotiations on other laws. You mentioned it, Mrs. Sippel, like the Data Protection Directive. So what do you expect in concrete after the ruling? How will it be implemented in these directives?
Now, first of all, of course, the data protection package is the first thing we have to review under these conditions after the ruling. But also, for example, the PNR rulings, we have to check what are the consequences here. And we have an ongoing debate also in European Union on what national services can do, the NSA, the German BND and other services, what they are allowed to do. And we are ongoing to say that national security in European Union nearly is not given because there is always a transnational aspect. So we have to find out what are our rules, where do we need to become better to control our services, not only in regard to the United States.
So lots of things to be checked after this ruling. Thank you very much, Mrs. Sippel. Thank you, Mr. Chase. Thank you, Olivier. Thank you, Pia. Thank you all. And see you soon on You Talking to Me.